Good afternoon. Welcome, and thank you for joining us for this afternoon's webinar on Is My Company in Compliance? How the recent SCOTUS decision affects employers. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Ward & Smith, and I'll be moderating today's presentation. Today's presenters are Xavier Lightfoot and Devin Williams. Xavier's practice focuses on a wide range of labor and employment issues, including personnel policies and handbooks, background checks, employment discrimination and harassment, employee discipline and termination, drug and alcohol testing, and various wage and hour matters. Devin's practice focuses on a wide range of labor and employment issues, including wage and hour matters, federal contractor compliance, employment discrimination and harassment, employee discipline and termination, personnel policies, and background checks. Devin also was recently elected to the position of co-managing director-elect. Again, thank you for joining us. Before we begin, I do have a few housekeeping items. We are going to utilize PowerPoint slides during this webinar, and we think it will be helpful for you to be able to see both our videos and the slides at the same time. To do this, you may need to make one adjustment to your view settings. Find the View Options button at the top or bottom of your screen and click on it to see your options. Then choose the side-by-side mode. The slide deck should appear on the left and our videos should appear on the right. You can then slide the separator to the left or right to adjust the size of each view. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. We also will try to answer as many questions live as we are able to during today's webinar. If you have a question, please type it in the Q&A box and I'll do my best to incorporate all questions into the discussion as time allows. Now, I'll turn the mic over to Xavier and we can begin.
Good morning, everyone. Thank you for being with us today. We have done a number of these presentations during the COVID-19 pandemic, and we've come to learn that the most effective way for people viewing the webinar to get as many questions as possible out there, because more than likely, if you've got a question, then most likely someone else has that same question or a related question. So to that end, if you have any questions, please pose those throughout today's webinar. We will address as many of those as we can going through the webinar today. The information we are going to discuss today is of great importance to HR professionals and employers. And I suspect that many of you are going to have some of the same questions as it relates to this new environment that we are now in, as it pertains to the protections afforded to individuals who identify as gay or transgender under Title VII of the Civil Rights Act. To get us started, we are going to first discuss a landmark decision that was handed down by the Supreme Court of the United States last month to the date. The case is titled Bostic versus Clayton County, Georgia. And I'll be referring to it throughout the webinar today as Bostic. In Bostic, the Supreme Court told private employers that the protections of Title VII of the 1964 Civil Rights Act, Title VII for short, those protections extend to individuals who are discriminated against because of their sexual orientation or gender identity. Before we dive into the court's legal analysis in Bostic, I think it's important for us to understand the significance of this case. So prior to the Bostic decision, less than half of the states had laws on their books that expressly prohibited employment discrimination based on sexual orientation or gender identity. A small amount of states had expressly interpreted their existing state laws to prohibit discrimination based on sex, to also include sexual orientation and or gender identity. So what that means is the remaining states, including North Carolina and 3 territories, did not have laws to prohibit this type of employment discrimination. So if a gay or transgender employee experience employment discrimination based on their sexual orientation or their gender identification, then they did not have a statutory basis with which they could pursue to seek some type of legal remedy at the state level for that discrimination. And that was the case in 25 states and 3 territories. Now that we have the Bostick decision, that means that all individuals in all states and territories are now afforded federal protection against employment discrimination based off of their sexual orientation or their gender identification. Those individuals who suffer that type of discrimination can either file a charge with the Equal Employment Opportunity Commission, EEOC, who will then investigate the charge and the underlying claim, and if there is some type of basis, will file suit on the employee's behalf, or subsequently, the employee can file a private lawsuit in federal courts against the employer. So it's important for us to understand how exactly we got to this decision. And it is truly a landmark decision. We've got with the global crisis that we have going on, it has somewhat been glossed over, but it is a very, very historic decision. And it's important to understand the underlying facts of the case that ultimately got us to the point we are now. So Bostick is made up of 3 separate federal court cases, and they arise out of 3 different appellate courts. The first case, for which the case is titled, came out of Clayton County, Georgia, and it involved Gerald Bostick. Mr. Bostick was employed as a child welfare services coordinator, and he had worked for the county for a number of years, and in all respects, he was an exceptional employee. Mr. Bostick was homosexual and identified as such, and once it became known to members in the community and to the county that he was gay through his participation in a gay softball league, then Mr. Bostick was terminated from his employment. And the county, Mr. Bostick accused the county of falsely accusing Mr. Bostick of mismanaging public funds. But the real reason that Mr. Bostick was terminated was on the basis of his sexual orientation. The case went to federal district court, and Mr. Bostick argued that he was fired based off of his sexual orientation, and that firing violated the protections under Title VII. The county argued that Title VII did not apply to Mr. Bostick's case because the language used under Title VII refers simply to sex. And so the county argued that sex does not include sexual orientation, which was Mr. Bostick's homosexual status. The 11th Circuit, the Federal Court of Appeal, agreed with the county and dismissed Mr. Bostick's lawsuit. Now, the federal court did that based off of older precedent that basically interpreted Title VII and said that, sex does not include sexual orientation. But the federal court also acknowledged and hinted that may have been a wrong ruling. That earlier ruling may have been wrong, but they were required to follow the precedent in that federal appellate court. So Mr. Bostick's claim was dismissed, and he petitioned for review to the Supreme Court. The second case, and Jim, we can move to the next slide. The second case underlying Bostick is a case out of New York, and it involved a skydiving instructor named Donald Zarda. Mr. Zarda also identified as gay or homosexual, and he would regularly employ a practice of telling female clients that he was gay and he had an ex-husband, just to make them more comfortable, being that, they were going to have a tandem jump. So he wanted to make them a little bit more comfortable and put them at ease. On one occasion, a female client actually complained to Mr. Zarda's employer that Mr. Zarda had acted inappropriately and touched her inappropriately, and Mr. Zarda was terminated from employment. However, Mr. Zarda argued that he was terminated because of his sexual orientation and on the basis of him identifying as a homosexual man. So Mr. Zarda sued in federal court under Title VII again, but this time the federal district court ruled in Mr. Zarda's favor at the appellate level. The Second Circuit basically said that Title VII does apply to discrimination based on sexual orientation because sex is necessarily a factor in sexual orientation. So the Second Circuit reversed the lower court's decision and basically said that Mr. Zarda had a claim under Title VII. The third case that makes up the Bostock decision, and all of these cases were consolidated and decided together. This case arose out of Garden City, Michigan, and it involved Miss Amy Stevens. Miss Stevens was a funeral director and embalmer at R.G. and G.R. Harris Funeral Homes, and she initially, when she was hired, presented as a man. She worked for the funeral home for a number of years as a man, and later was diagnosed with gender dysphoria. Miss Stevens informed her employer that she wanted to live and work as a woman prior to having undergone sex reassignment surgery. Miss Stevens' employer identified as a devout Christian, and he did not want Miss Stevens to represent herself as a woman, and he was completely against the idea. He believed that this would violate God's commands. And so Miss Stevens' employer terminated Miss Stevens on that basis. And so Ms. Stevens filed a discrimination charge with the EEOC, who pursued a complaint on her behalf and actually sued the funeral home in federal court. And so the federal court ruled in favor of the employer at the district court level. And the district court reasoned that transgender status is not a protected trait under Title VII. Another key point in Ms. Stevens' case is that the funeral home also raised a defense, which we will discuss in greater depth throughout the webinar, under the Religious Freedom Restoration Act, which basically precludes the government from enforcing Title VII in instances where it would result in a substantial burden on the employer's religious exercise. So when the case got to the Sixth Circuit Court of Appeals, the court reversed the lower court's decision, and they held that discrimination on the basis of transgender and transitioning status is, in fact, discrimination on the basis of sex. And that court further ruled that the Religious Freedom Restoration Act defense that the employer asserted did not apply to protect the funeral home's actions, because the funeral home was, one, not a religious institution, and two, Ms. Stevens was not a ministerial employee who was excluded from Title VII's protections. So in that case, the court actually went a little bit further than the other two federal courts in discussing that defense of religious under the Religious Freedom Restoration Act. Jim, we can move forward. And at this time, what I'm going to do is I'm going to turn it over to my colleague, Devin Williams, who's going to discuss the legal analysis that the court applied in the Bostick decision.
Thank you, Xavier. So as Xavier mentioned, in 2 of the 3 cases, which this often happens if cases are combined on an issue such as this before the Supreme Court, 2 of the cases, the employers argued there was another reason for the individual's termination, that it wasn't based on sex or sexual orientation or transgender status. And then you heard the funeral home case where the funeral home director actually indicated that yes, in fact, it was a termination because the person was transgender or transitioning. And this is, an important piece to note, because it shows that, these 3 cases got to the Supreme Court because of a split among the circuits, but also it shows that given the right fact pattern, there are lawyers and attorneys that are going to want to have issues such as this before the Supreme Court. And this is just an example of that, where 3 of them, or 2 of them originally started with another reason for the termination, but they ultimately abandoned that and fought on the issue of whether discrimination on the basis of sex includes sexual orientation or transgender status. We've already forecast for you that what the Supreme Court's majority holding was, and it is as simple as this: that an employer who fires an individual merely for being gay or transgender violates Title VII's discrimination on the basis of sex. The court went on, and again, this was a 6-3 decision, so not a swing vote type of situation. But in describing its holding and its analysis, the court also talked about this distinction that sex is intertwined with sex-based decisions and factors. And you may have attended prior events with us where some of our labor and employment attorneys opined prior to this case arriving at the Supreme Court that the way the EEOC viewed it is that essentially an individual who is gay or an individual who is transitioning or a transgender individual, that an employer making a decision based on those distinctions, those classes, if you will, or categories, you necessarily have to factor in what their biological sex is and the fact that they are not conforming to the traditional norms associated with that biological sex. That was the EEOC's view leading up to this case, and the majority's opinion goes along with that analysis of saying that, and they do it through what's called a statutory interpretation textual analysis, where they are basically looking at the meaning of the words discrimination on the basis of sex. They acknowledge that it has to do with biological sex, male, female, but that an employer then, in order to take adverse action against a gay individual or a transgender individual, they are doing that in part because they do not conform with the biological sex. And for example, let me read something to you from the majority opinion that describes this a little bit more. An employer who discriminates against homosexual or transgender employees necessarily and intentionally applies sex-based rules. An employer then announces it will not employ anyone who is homosexual, for example, intends to penalize male employees for being attracted to men and female employees for being attracted to women. And conversely to that, the employer would not be penalizing male employees for being attracted to female and female attracted to male. And this was, while this is a landmark and a very important decision for jurisprudence as well as for the LGBT community, it also is not surprising given what the EEOC has been saying for many years now. But what is also interesting is looking at the dissenting opinions and the legal theories that they brought out. So Justice Alito was joined with Justice Thomas in dissenting from the majority opinion, and then Justice Kavanaugh also dissented but wrote his own opinion. Justice Alito's dissent is quite long. It's actually twice or three times as long as the majority opinion. And he has some colorful arguments in there. And I included one quote because this seems to be something that he may go down in history for, particularly liking the majority opinion to a pirate ship. And essentially, he focuses on the two things, one being that the court has engaged in legislation from the bench, and by ultimately deciding that the term discrimination, or the phrase discrimination on the basis of sex, includes sexual orientation and transgender status, Justice Alito and Justice Thomas view that as taking the decision, usurping the power of Congress to legislate, and that they are legislating from the bench by adding those terms into it, and that if you were to do a strict interpretation of the text and what it meant at the time that it was passed, which would have been 1964, that no one would have intended or thought the term, discrimination on the basis of sex included sexual orientation or transgender status, and that in fact it only included sex-based discrimination between male and female. And so Justice Alito's quote here about comparing the court's analysis and what they've done to a pirate ship, and also referencing multiple times his former colleague on the bench, Justice Scalia. Justice Scalia was a very strict he would strictly construe the law and text, and he wrote many treatises on textualism and how to construe phrases and what they mean in legislation, and to avoid what Justice Alito is accusing the majority of doing, engaging in legislation from the bench. So that was Justice Alito, and again, I think he's gotten criticism for his opinion, and the pirate ship comment being somewhat of a comical comment to put into an opinion of this nature. But he very well may go down in history for this particular dissent. Justice Kavanaugh focuses on two things also, and they're very similar between what these three justices are saying in these two dissents. But Justice Kavanaugh focuses on one, that he also agrees that it was not the court's role to add in sexual orientation and gender identity to Title VII, that as it should be interpreted under its ordinary meaning from the discrimination on the basis of sex, that was intended to include biological differences between male and female, not to write in these additional elements of sexual orientation and gender identity. And this ordinary meaning versus literal meaning is an interesting concept that he talks a little bit about. And basically what he's saying is that it has always been the court's role to construe statutes and phrases and terms as to their ordinary meaning. What does a reasonable person believe that term or that phrase means in the context of the statute versus a literal meaning. And the literal meaning, such as if, for example, Congress decided to write a statute with the words, they talk about tomatoes or beans and seeds, and that beans may be seeds. He uses this as an actual example. He's saying you shouldn't necessarily give it its literal meaning. What did it mean in terms of how it was used in the context? And the best example that he gave was that if there was a statutory ban on vehicles in the park, quote, vehicles in the park, we would traditionally, ordinarily, consider that to be motor vehicles, likely, or anything that had, whether it's a motorcycle or an automobile or a truck, a four-wheeler, something like that. We would traditionally think that's what it meant, or ordinarily that would be the meaning we would apply to it. But if it was construed literally, then technically a baby stroller could constitute a vehicle in the park that would be prohibited. And so his argument, and he that takes it a little bit far when you come up with examples like that. But that he focused a lot on the ordinary meaning versus literal meaning. And saying that the ordinary meaning of sex or discrimination on the basis of sex has always been male-female equality, not this additional layer of sex-based discrimination, which he also said, if that's true, if it's sex-based, if we're taking another step in that direction, then that could also bring into play, sexual assault victims, domestic violence, and things of that nature. And so anything that has a connection to sex could theoretically, under a literal meaning, fall into discrimination on the basis of sex. However, he did at the end of his opinion note that despite his dissent, he recognized that this was a victory for the LGBTQ community. His dissent, though, is mostly based in part because he felt the court applied terms to discrimination on the basis of sex that were not there, that Congress did not intend, and that it was not the court's role to essentially update Title VII to fit the 2020 environment that we are in and culture that we live in now, and that should be left to Congress. And so the court should not have added in those terms, those protections, and rather left it to Congress under the separation of powers. But those are, so that kind of breaks down the majority opinion and the dissents to give you a flavor for ultimately how the court reached this groundbreaking opinion. And it's groundbreaking, not necessarily because we didn't see it coming, but because of, one, it is a victory for the LGBTQ community. It now settles a very contested issue that has been litigated all over the country. But what's also important to note here is, as the Supreme Court tends to do, there's a lot that was left unanswered and unaddressed by this case. And so let's talk about what was not covered by Bostock. And particularly, and the majority opinion talks about this, and this relates to what Xavier was mentioning with the funeral home case, is whether a religious exemption or exception could apply that would give an employer a defense to, intentionally discriminating against an individual because of his or her transgender status, or for being gay, or for their sexual orientation preference. And ultimately, because the funeral home case, the funeral home director abandoned his Religious Freedom Restoration Act defense, the court did not take that up. And the court, near the very end, actually, I think it's next to the last page of the opinion for the majority, the court acknowledges that they are not addressing this issue because it's not before them, because the funeral home director relinquished that defense and there were no other issues raised as to whether a religious exemption could apply. But the three main religious exemptions that would be possible or issues that we expect to see in the future, because this is clearly by the text of the opinion is left open for debate and is left open for future courts to decide. But there's the three exemptions or exceptions that you see on the screen. The first, Religious Freedom Restoration Act, a relatively new law, but 1993 law that Congress passed. And essentially what this requires or prohibits is that the federal government cannot substantially burden a person's exercise of religion unless it demonstrates that doing so furthers a compelling governmental interest is first, and that it is the least restrictive means of furthering that interest. In the funeral home case, the Sixth Circuit ultimately decided that the prohibition, they had interpreted Title VII to cover transgender status, and the Sixth Circuit said that governmental interest of protecting against discrimination on the basis of sex, to include transgender status, was a compelling governmental interest, and that it was the least restrictive means of doing so, that by having that person employed did not create an undue burden on the employer's exercise of their religion. You'll also maybe remember the Hobby Lobby case, which was similar and addressed this. Hobby Lobby did actually get that defense in that case. And so there's a question of whether future courts will abide or follow the Sixth Circuit, because that is, as to that small issue, that is binding precedent in the Sixth Circuit, that the RFRA does not give an employer a defense to Title VII. However, that issue, again, was not taken up by the Supreme Court, so other circuits could decide otherwise, and district courts outside of the Sixth Circuit could rule differently on that issue. The second is kind of a more obvious exception for religious organizations, and it's specifically provided under Title VII. And the court, again, briefly addressed this just really by mentioning that it exists and that it is included in Title VII. And so religious organizations, those, think of your churches, your synagogues, schools that are so intertwined with the church facility that they are essentially an extension of the church, would qualify as a religious organization. And potentially other, nonprofits that again are have a religious foundation in some way. And so it's a smaller group of employers that are going to qualify as a religious organization. And then that presents the question. So one, you've got to meet the definition of religious organization. And then two, now it's still unanswered whether that the category of extending the protections from discrimination on the basis of sex to gay individuals or transgender individuals would put you under that exception and provide you a defense from having to do that. And then the third one is tied to the First Amendment and the free exercise of religion clause. And this relates to the ministerial exception. And that one is, again, as its name forecast, you're talking about your pastors, your ministers, and folks in a position of an official position within the church or the religious body that for example, it's traditionally viewed that, a church would not have to accept a gay individual as their minister. And so that minister who's not hired because of being gay, technically otherwise would have a claim under Title VII, but this particular exception may give the employer, the church, a defense to that completely. And since Bostock came out, there's been 2 cases from the Supreme Court that have addressed religious issues, and one was relating to the ministerial exception, where they extended that to age discrimination and disability discrimination. And so, and that decision actually was a 7-2 decision. So that can lead us to, while we still don't have an answer, and it could be an issue to be addressed later, the Supreme Court's most recent decision on that issue provides maybe a little bit of a forecast that of the 3 listed here, the ministerial exception is the one that's most likely to be successful for an employer. And again, that's going to be limited to what you would traditionally view as employers who employ a minister or another officiant type of role. So the next issue that the court specifically punted relates to bathrooms, locker rooms, and dress codes. And not as much with dress codes, but certainly with bathrooms and locker rooms. And what the court said here is the reason the court addressed this briefly by acknowledging that they are not going to address it is because the dissenting opinions alleged or attacked the majority opinion on the basis that this decision to extend protections from discrimination on the basis of sex to sexual orientation and gender identity is going to open up a whole host of other issues that the court is not called upon to address at this time, and it's going to have far-reaching consequences. And the majority's response to that was essentially, that's not our role to not decide a case because it's going to have far-reaching consequences. But the court did acknowledge that one of those areas where admittedly it could have implications is with the bathrooms, locker rooms, and the dress code issues that arise in employment. But it specifically said we're not going to address what kind of policies or practices are appropriate, and that's for future courts to address if those issues arise. And certainly those issues will arise. And essentially the reason they punted that is, again, as I said earlier, Supreme Court did what the Supreme Court often does. They find the most narrow issue that they are called upon to address. And in this, the court said it was simply, the only question before us is whether an employer who fires someone simply for being homosexual or transgender has discharged or otherwise discriminated against that individual because of such individual's sex. And as we now know, the answer to that question is yes, that would be discrimination on the basis of the individual's sex with the court's opinion. So with kind of understanding the in-depth analysis of the majority's opinion, the things that they addressed, the things they did not address, and the dissenting opinions, we wanted to dive into some hypothetical scenarios. You may find them not to be so hypothetical. You've maybe dealt with something similar. If you have not, I can assure you that you will at some point in the future deal with issues that are very similar to this. And so I will hand it off to Jen, who is going to help guide us through some of these hypothetical scenarios.
Great. Thank you so much, Devin. Before we get into the scenarios, we did have one question from our participants that I think is timely. So the question is, if our company has a transgender employee who was male and transitioned to a female and now wants to use the women's bathroom, can we deny that request if other employees say this is against their religion?
I'll attempt to tackle that one. So at this time, if I'm gonna give you advice kind of flat-footed, my advice would be denying that request on the basis of an individual employee's religious exercise is not going to be a defense. With the defenses that we just talked about on the religion side and the free exercise of religion, those are traditionally going to be tied to protecting a private employer from having the government tell it what it can and cannot do, and that infringing a religious freedom. It does not mean that an employee who comes in and says, you know, by me having to use the same restroom as a transgender individual, that violates my personal religion, that is technically not going to satisfy one of those defenses. However, what that could present, and it could be a very complicated situation that you have to navigate, but you have on the one hand the transgender employees, you know, even whether you look at it as a preference or the identity issue of they need or want to use the women's restroom. And then on the other hand, you have an employee who is coming to you saying, I disagree with the employer's policy that allows that individual to use the women's restroom. And so is there an accommodation, a religious accommodation that the employer can provide to the employee who has a concern, a religious concern, with the employer's policy to allow the transgender individual to use the bathroom with which they identify? And so then you might be in a situation of having to look at if there's other accommodations that you can provide to that individual that would, not, it's not infringing their religion, but that would accommodate their concerns while also allowing the transgender individual to use the women's restroom. That's gonna be a tough one if it comes up, and I suspect it will come up, particularly with the environment that we're in presently. And one option that might be for a religious accommodation under Title VII for that individual, it might be if there's a gender neutral stall that the individual who has a problem with it could use, or somewhere else that they feel comfortable. But ultimately the employer would not, if it creates an undue burden on the employer would not have to accommodate that individual's request or concern. But certainly there would be practical issues that you would want to try to navigate delicately.
Great, thank you so much, Devin. We'll dive into our scenarios now. In just a moment, I'll read a fact pattern, and then there'll be a couple of follow-up questions. We'd love to hear from our participants about their answers to these questions. So feel free when the time comes to type your answers in the chat box, and we'll take a look at those, and we'll go from there. So moving on. Acme Engineering, Inc. is an engineering firm based in Raleigh, North Carolina. They currently employ 90 engineers. Jared, a hiring manager for Acme, wants to hire a male engineer to add to his team. His team currently consists of 15 male engineers. Jared interviews and hires Mark, a very qualified engineer. Mark presented as a man during his interview process with Jared. After 3 months of employment, Mark is diagnosed with gender dysphoria and desires to express his true self and openly present as a female. Mark talks to Jared about this and says he will present as a woman, is changing his name to Martha, and desires to view trust with the pronouns she, her, hers. Jared is infuriated and wants to terminate Martha because she will no longer present as a man. So our question for everyone is, can Jared terminate Martha on this basis?
And we encourage you, if you want to respond. Okay, we're getting great. We're getting some responses back in. Xavier, can you share a little bit with us on your thoughts on what Jared or the employer should be doing with this particular situation?
Absolutely. And as Devin mentioned, we are getting great responses, and you are on the ball on this one. The answer is absolutely not. This hypothetical we have is actually what we discussed in Miss Stevens' case, who was the funeral home director. If an employee informs the employer that he or she is transitioning and wants to present as their true self, whether it be male or female, and the employer's reaction to that request is to terminate that employee on that basis, then that is going to constitute a Title VII violation. It's going to constitute discrimination under Title VII. And that employer is going to be subject to the violations that you can incur under Title VII. And so it's important to understand that, the Supreme Court has ruled on this, and this is the law of the land. You are not going to be able to terminate an employee because he wants to transition to a woman and express themselves and present as a woman. You're not going to be able to terminate an employee because she wants to transition to a man and express himself as a man. That's not something that you're going to be able to do. And you want to make sure that you understand that and avoid that reaction if, you are inclined to have some type of opposition to the request, because this has been ruled on, and this is going to be the law moving forward.
Thank you, Xavier. So thinking of the exact same scenario that I just read about, the next two questions are twofold. Should Jared respect Martha's pronoun preference of she, her, hers? And are other Acme employees required to respect Martha's pronoun preference?
So yes, that would be our recommendation for employers. We also recommend that we think this is going to be a potential issue for some employers, because you're going to have employees who refuse, on whatever grounds, personal conviction they may have, not to oblige the person, the transgender individual, with the pronoun preference that they've indicated. But as Martha's supervisor, can immediately bind the company if he continues to refuse to refer to her as based on her pronoun, or pronoun of her choice. Other employees that you have could also subject the employer to liability by not referring to Martha by her pronoun preference. If they continue to do it, it could then constitute harassment on the basis of sex based on the Bostick decision. And so what we are encouraging employers to do, or to consider doing, is training. You may already do training with your employees on sexual and other unlawful harassment, and adding this in as now a protection is very important. And going through and explaining, educating your employees and supervisors in particular about sexual orientation and transgender identity. And some of that can mean, you know, folks may not realize that if Martha still looks like Mark, except for maybe how she dresses or the bathroom that she uses, they may just instinctively continue to refer to Martha as Mark, or refer to Martha as he, his, that kind of thing. And so it may be almost innocently done, but if it happens, if it's from Jared, or if it happens enough from other employees that Martha has complained or raised it as an issue, that could subject the employer to liability of allowing a hostile work environment to occur. And so education is very important. You know, explaining that pronoun preference isn't very important in the transgender community. Also going through other definitions of, you know, transgender individual and how you refer to them if they are transitioning, what words to avoid, what words in the LGBTQ community are viewed as derogatory, because some folks just may not be educated on it and may not know. Other folks who are doing it intentionally, of course, they do know what they're doing, and you need to enforce your sexual and other unlawful harassment policy against them and take appropriate disciplinary action to eradicate that type of treatment. Otherwise, I think very well you will see an uptick in harassment cases that are brought by gay or transgender individuals based on how their colleagues are treating them and or their supervisors.
Thank you, Devin. And during this discussion, there was another question for follow-up. What are damages for a Title VII violation?
Yes, so there are statutory damages that are going to be based on the number of employees you have, where there's a cap on certain damages up to, for example, if you have, and off the top of my head, I'm not sure of the exact number, but if you have 15 employees to 50, it might be capped at 50,000, and it can go all the way up to 300,000 for each violation. In addition to that, oftentimes with Title VII violations, we see multiple claims that might be under Title VII. So each of those claims, even though they're under the same law, for example, discrimination is separate and apart from hostile work environment or harassment. Those statutory caps would also apply there. And then oftentimes, if there is a Title VII violation, there's likely to be a state law claim of some nature. Whether you're in North Carolina or you're in another state, I think of California as having a myriad of laws that would tack on to a Title VII violation or claim. And so those laws also will come into play. So while there can be a statutory cap on your ultimate damages under Title VII, it's still, you know, for these individuals who, or these companies that were in these cases before the Supreme Court in Bostic, you know, they expended significant legal fees trying to fight this. And they were a test case, and so they will be forever down in history on this issue. But yeah, it is statutorily capped. You look at back wages, front pay, compensatory damages, that kind of thing.
Thank you, Devin. We're going to move on with our scenario. And keep in mind, we're still at Acme Engineering, and Martha has had her discussion with Jared about identifying as a woman, but we're going to change the facts of this scenario a bit. So Jared now has indicated he has full support of Martha presenting and will respect her pronoun preference. Martha informs Jared that she will use the women's restroom on their floor and will also use the women's locker room after her workouts at the company's gym. Laura and Stacy, two women engineers on another team at Acme, have expressed privacy concerns to the Director of Human Resources indicating they are uncomfortable with Martha using the women's restroom and locker room. So our questions for our participants are, can the HR director terminate Martha if she chooses to use the women's restroom and locker rooms? And how should the HR director navigate this situation?
I can tackle this one. We've actually already covered it, and it came up in the question that was first posed to us. So to answer the question directly, can the HR director terminate Martha if she chooses to use the women's restroom and locker rooms? Well, no. That is not going to be a proper reaction, and it is likely going to be that some type of discrimination lawsuit is going to come from that, and likely under Title VII. How should the HR director navigate this situation? Well, again, it goes back to having conversations with the employees who are expressing the concern, and informing them that the company has to take a position, a non-discriminatory position. And it may be one option that you want to provide a gender neutral bathroom or locker room for that individual who is complaining and expressing those privacy concerns. Or it may be you just want to, find somewhere else where they can, use the restroom and change in the locker room without having to be put in a position of uncomfortability. But what you are not going to want to do is to terminate the employee who has expressed that they will use the restroom that does not apply to the gender that they were born with. You don't want to do that, and you don't want to make them feel like they need to do something else or find some other type of accommodation. So you're going to want to tackle it from the side of the employees who are expressing that concern. And that's how you're going to avoid a situation where you come into any type of trouble under Title VII. Going back to the question as to, what type of damages you can get under Title VII. One of the things that the law is designed to do is to place the victim back in the position that he or she was in before the discriminatory conduct occurred. So you can be in a situation where not only do you have to pay some type of monetary damage, but you may also find yourself in a position where you have to return that employee back to their position. And that is something that you will want to be mindful of, that those remedies go beyond just the monetary damages.
Thank you, Devin. Excuse me. Thank you, Xavier. So we have a couple of questions, and we have a little bit of time here. So if you do have additional questions, please feel free to type them into the Q&A, and we'll answer them before we wrap. The first question was a follow-up to the damages for Title VII violations. And the question was, what are the violations for companies with less than 10 employees? Devin, I know the example you gave was 15 and over. So this is a smaller company with less than 10 employees.
Yeah, so a company with less than 10 employees, again, you want to look at, for 20 or more calendar work weeks in the preceding or current year, that employer is not going to be subject to Title VII. And so you would have a jurisdictional defense that you are not covered by Title VII as an employer. And therefore, an individual could not bring a Title VII claim against that company. However, there could be other state law claims that the individual could bring against you. And another thing just to keep in mind is because the Supreme Court has interpreted the language in Title VII, discrimination on the basis of sex, to include sexual orientation and gender identity. then in North Carolina, for example, with our equal protection clause in employment, that discrimination could be extended, sex-based discrimination could also, the same interpretation could be applied, and the Bostick decision could be used to persuade and or possibly bind a North Carolina state court that North Carolina's law has the same exact language and therefore should be interpreted the same way as far as the discrimination on the basis of sex. So sex extending to sexual orientation and gender identity. We have no indication of that being the case, but that is something to keep in mind, that the Supreme Court's decision as to a federal law and the language it interpreted could be extended to state statutes that have similar language or similar protections for discrimination on the basis of sex. So again, not subject to Title VII in that particular setting, and so not having to worry about Title VII damages or punitive damages or statutory caps and that kind of thing. But there certainly could be other state law claims in play for that company.
Okay. And it looks like we have a final question before we conclude. If we have a uniform policy that men wear suits during certain functions and women wear dresses during those functions, because these are the types of attire our customers wear at these functions, can we preclude the attendance of an LGBTQ employee who insists on wearing clothing that does not appear consistent with his or her gender?
So I can tackle that one, and then I'm happy to have Xavier chime in as well. My interpretation of the court's opinion would be that no, by precluding the attendance of an LGBTQ employee who, whether transitioning or a transgender individual, is wearing clothing that they consistent with their gender identity, even if inconsistent with their biological sex, that would be discrimination on the basis of sex as interpreted by Bostick. The concern with dress codes that have a distinction between what men can wear and what women can wear, or for example, how how long a man's haircut can be versus how long a female's hair can be, those policies are risky at this point, because especially if you apply it based on biological sex versus gender identity, in that situation, I think this is one of those examples that the court was forecasting that, hey, we're not addressing this, we're not getting into a policy, whether a policy like this is appropriate or lawful, that's for future cases. And this type of situation would be the future case where I think the court would ultimately rule in favor of the LGBTQ employee. Xavier, do you have any comments you'd like to add on that?
Yeah, I completely agree with your analysis, Devin, and I'll say that in one of the cases, going back to the Sixth Circuit case in Boston, and that was Miss Stevens, the funeral home director, the Sixth Circuit actually got around the employer's religious exercise or religious freedom defense by saying that, hey, one of the facts in that case was that the employer had a stipend in which he would buy suits for the male employees, but would not provide a stipend for dresses or suits for women employees. And so the fact that there was that distinction, that constituted discrimination on the basis of sex. And I think that, taking that a little bit further to this, this question, even mandating that someone wear a dress if they prefer to wear a suit because that is, how they identify as, and that is their true self, then that is going to likely constitute discrimination on the basis of sex. And as Devin mentioned, those type of policies are risky, and you want to be mindful of these issues because they are certainly going to come up, and you're certainly going to have to address them. And one thing that you don't want to do is you don't want to be a test case for the court to expand on its jurisprudence and potentially it not be in your favor.
Great points, Xavier. And absolutely, I think we say that oftentimes with employers, you don't want to be the test case. And so interpreting the court's opinion as broadly as you can to extend those protections to individuals on the basis of sexual orientation and gender identity is the way to go to avoid potential liability and extensive legal fees. I wanted to go back and add one thing on the damages question that was raised and clarify. So there's a statutory cap for employers based on the number of employees they have as to compensatory damages. And that's going to be things like pain and suffering, emotional distress, you know, the kind of, even though it's a monetary damage, it's a non-monetary issue that you're compensating the person for. Those are capped, and it goes up as you have more employees, the greatest being 300,000 for very large employers. On the other hand, things such as that are truly monetary from resulting damage from the harassment or discrimination or the termination, such as back pay or front pay, things that can be actually proven as part of the person's direct damages, those are not capped. So you theoretically could have an individual who is paid, you know, very significantly and have, you know, significant back wages or back pay that is due as a result of an unlawful termination. And then the person would theoretically be entitled to that amount, possibly front pay, which would be outside the cap. And then the compensatory or punitive damages would be what is capped. So there's, you know, there is a cap, but it doesn't insulate you completely. So just keep that in mind. Another reason to not put yourself at risk in these situations just because of the damages and what could be at stake.
Thank you, Devin. We have one last question come in that I can actually address. And the question was, does Warden Smith offer any training for any of these issues? And the answer to that is yes, absolutely. We're going to conclude today's seminar, and thank you so much to Devin and Xavier for speaking with us today. For those of you in attendance following this webinar, I will send an email to all of our participants. It will include a list of articles related to the issues we discussed, information about our new online handbook policy review service, a link to sign up for our labor and employment mailing list, and I'll also include Devin and Xavier's email addresses. So of course, if you would like to offer training for your employees on any of these issues discussed today or other employment issues, it's absolutely something that we can explore with you. If you do have interest in having your LGBTQ and EEO handbook policies reviewed, as I mentioned, we do have an online service about that. Please don't hesitate to reach out to us for more information. It is a flat fee for this service, but should you choose to have your policies reviewed, the registration cost of attending today's webinar will be credited towards that fee. As a friendly reminder, we are recognized by SHRM to offer professional development credits, and HRCI and CLE accreditation approval is pending for this webinar. Warden Smith will submit accreditation materials for attendees seeking North Carolina CLE credit only. If you need out-of-state CLE credits or any information required to submit SHRM or HRCI credits, please email us. I can provide you with the certificate of attendance and webinar materials, and all of that information will also be included in your follow-up email from today. Again, thank you so much. Warden Smith appreciates you taking the time out of your day to join us. We hope you were able to take some of this information and apply it to your own business. Thank you again, and this concludes today's webinar.
Thank you.
Thank you.